Çok sevgili İGAM takipçileri tekrar merhaba. 20 Haziran Dünya Mülteciler Günü etkinliklerinin ikinci oturumundayız. Sabah çok güzel bir açılışımız olmuştu ve İGAM ödüllerini aslında sizlere sunmuştuk. Eğer sabahki yayını bizimle birlikte takip edemediyseniz sonrasında YouTube'dan tekrar kaydı izleyebilirsiniz. Onu da hatırlatmış olalım. Bu öğleden sonranın oturumunda da çok önemli konuğumuz var. Profesör Doktor Goodwin-Gill. Onu dinleyeceğiz. Küresel Mülteci Mütabakatı üzerine ve tabii ki de Dünya Mülteciler Günü'nü aslında etraflıca uzmanlarından takip ediyor olacağız. Ve böyle önemli bir misafiri de aslında misafir edecek yine çok önemli bir isim var. Çok kıymetli, kendisi çok kabul etmese de ben bizim duayenimiz demekten kendimi alıkoyamıyorum. Profesör Doktor Kemal Kirişci hocamız aynı zamanda da bizi onurlandırıyor İGAM'la olan birlikteliği sayesinde ve İGAM-Academy'nin de başkan yardımcılığını yürüterek. Efendim bu çok kısa açılıştan sonra ben sözü uzatmadan üstadlarımıza bırakmak istiyorum. Kemal Kirişci hocama ilk olarak sözü vereceğim. Bir not geçelim. Tabii programımızın dili İngilizce olacak ama daha sonrasında bu programın çevirisini ve Türkçesini de yine İGAMTV YouTube kanalında takip ediyor olacaksınız. Herkes için iyi oturumlar olsun. Sevgili Kemal Hocam söz sizin. Buyurun lütfen.
Teşekkür ederim Nihal. Herkese hoş geldiniz diyorum. Dear Guy, don't worry, we will proceed in English from now on. I suspect you figured out, deciphered the introductory remarks that Nihal just made. I need not to mention how exciting and how exhilarated I personally am, but also the followers of IGAM. Very briefly, IGAM is a small think tank, but it's more than a think tank that was established about 8-9 years ago. Its name comes from the Research Center on Refugees and Migrants. But with the situation that I'm sure you're familiar with in Turkey, Turkey being, as the UN Global Trends that just come out for its 7th year, is the country that hosts the largest number of refugees, IGAM is also involved in projects in the field. And today, this morning here in Istanbul, 2 awards were given. One was on Talat Miras. You might know of him. He was one of the vice presidents of the plenipotentiary conference that drafted and then accepted the 1951 Geneva Convention. So that award was given to a Turkish person or organization active in the field with refugees. And then, as interesting as that, there was an award given to a non-Turkish person or organization in the name of Angela Burdet Kutz. She, in the late 1900s, around the time of the Ottoman-Russian War, she did something very unusual for a Westerner and an English lady. She organized help for the Muslim victims of that war, especially those who became displaced. And this afternoon, we're looking forward to hearing your intervention, Guy. I'd like to very briefly introduce you. I'm very fortunate that I go a long way back with Guy. My memory is somewhat failing, but I suspect we may have first met in the early 1990s. But the event that I remember the most is when we went to celebrate the 50th anniversary of the convention in South Africa, in Pretoria, if I remember correctly. Of course, the world has changed significantly then, and I'm hoping that in your intervention, you will also give us a feel of how far the world has changed. I'm afraid it feels that it has not changed to the better in terms of refugee protection. And then let me also mention, and I hope our friend Anil may have the opportunity to introduce how your classic, dare I say, the Bible of refugee protection and the law on refugees, it comes onto the screen. It's not coming, so it's a book. I say it's a Bible because it's a classic that every, at least academic interested in refugee studies and especially the legal aspect of it, ought to be familiar with. I have used it extensively and benefited from it greatly. But of course, your publications go beyond it, and I won't take too much time dwelling into the details of it. But allow me just to mention that right now you are in Australia at the New South Wales University, but previously you were at Oxford University in England, and you have a long career, academic career in the study of refugee issues, and you have also served with the UNHCR in various duties. So we are all very fortunate that you are able to join us, even though it's almost midnight at your end of the world, and we look forward to hearing you. And then there will be a brief discussion and Q&A session, and hopefully we'll let you off the hook before it actually is midnight in Australia. Guy, the floor is yours, and we're delighted that you're with us. Thanks.
Thank you. Thank you very much indeed, Kemal. And I seem to have a better memory than you. I think we first met Campbell in 1991, celebrating the 40th anniversary of the convention in Geneva. I remember it very well.
I was a young man playing soccer for a Scottish team, where the name Campbell comes from too, I suspect. Yeah. Thanks.
Yes. Anyway, I have been asked to deal with the question of the International Refugee Regime and its challenges, which I'll try to do. I mean no disrespect when I say that every few years or so, I tend to find myself giving a talk on the challenges to the International Refugee Regime. It's as if the regime cannot survive in the absence of challenges, and perhaps this is true. For international refugee law is a dynamic environment, necessarily dependent on the latest in an everlasting succession of displacement crises. UNHCR's Global Trends, published just 2 days ago, tells us that despite the pandemic, the number of people fleeing wars, violence, persecution, and human rights violations in 2020 rose to nearly 91.9 million people, a further substantial increase over the already record high 79.5 million in 2019. And that makes 2020 now the 9th year of uninterrupted rise in the numbers displaced. And Turkey, as Kemal mentioned, leads the field, hosting some 3.7 million refugees, most of them Syrians. And each displacement is sufficiently the same as the one before, and yet subtly different also, requiring past judgments to be refined and finessed, and calling for new eyes to look at old problems and come up with perhaps new solutions. Not that it ever quite works out that way, of course. Today on World Refugee Day 2021, we choose to celebrate 70 years of the 1951 Convention relating to the status of refugees. The draft text was finalized and open for signature in Geneva on the 28th of July, and it seems to have stood the test of time, notwithstanding its inadequacies. But on that, we shall have to see. By way of introduction, however, I want to turn the clock back another 30 years and to note that it is 100 years this year since the appointment of Fridtjof Nansen as the first High Commissioner for Refugees in 1921. In that year, the world, looking back, was apparently simpler, and the problem of refugees appeared to admit more readily of solutions. Indeed, with regard to one group of Assyrians in Iraq in 1920, the British government approved their being supplied with, I quote, rifles and a few mountain guns, and left to make out as best they could, which they did. But at that time, 3 years after the end of the First World War, at a time when Turkey was engaged in its own war of independence, refugees were very much an agenda item among states, then newly organizing in a League of Nations, which was just not able to cope with a population without national protection. Could international law or international organization provide any answers? 100 years ago, the Russian Civil War drew to a close, and the British and the French were busy evacuating from the Crimea their own erstwhile allies, both military and civilian, in the White Russian resistance. In February 1921, Gustav Adolf brought up with the President of the League Council the urgent problem of several 100,000 refugees then adrift in Europe and elsewhere. He mentioned 800,000. The number, in fact, was at least 1.5 million. Many were adrift and without protection, written off by their country of origin with no prospect of settling locally, of finding employment, let alone of moving on to other countries. Relief was not enough. The resources of voluntary organizations were rapidly diminishing. Something had to be done, and many saw the League as the only organization able to overcome political and social difficulties and come up with solutions. Governments agreed that something had to be done. And the idea of a high commissioner took root, someone who would define the legal status of the refugees, organize their repatriation or allocation to other states, find them productive employment, a recurring theme, by the way, and together with philanthropic organizations, undertake relief work. This would cost money, of course. It was briefly thought that funds belonging to former Russian governments at present deposited in various countries might be used. For legal reasons, nothing came of that idea. In 2015, I co-authored an article with Selim Khan-Sazak on the subject, which was then raised again in 2018 by the World Refugee Council. Whether it too will sink, we shall have to wait and see. I hope not, because using funds of refugee-producing countries could send an important message. What is significant at the time of 1920s, though, is the acceptance of a range of factors as drivers of displacement: conflict, statelessness, famine, and epidemic. It was not disputed that they gave rise to movements across frontiers and that something had to be done, but what exactly should be done? Now, at the time, law and anything resembling individual rights were not immediately part of the solution. Nonetheless, certain basic principles were emerging. The idea that the refugees needed to be able to identify themselves, for example. They needed to have freedom of movement if they were to be able to move on to where work was available. National labor markets needed to open up also, and equality of treatment ideally would be the norm. Above all, however, it was taken for granted that no one should be sent back to their country in the absence of sufficient guarantees of security. A point on which the 1921 conference agreed, even before the appointment of the High Commissioner. This fundamental position of principle was practiced long before the word non-refoulement entered the vocabulary of protection. In 1923, Nansen intervened to protect Russian refugees in China, to protect another group whose, and I quote, previous political associations were such as to render dangerous their presence in Constantinople. Another group of refugees threatened with expulsion for military reasons from Romania. Yet more refugees in Poland who were alleged to have left their country not on political grounds, but for economic and other reasons. And Nansen succeeded in preventing expulsion. He succeeded because of the support of other states, which offered relocation possibilities. War and revolution, the traditional drivers of refugees, had devastated the economies and social fabric of many nations. But there were also other worrying reasons. Mortality in Russia was about 4 million above average for the civil population between 1918 and 1920. And from October 1921 to June 1922, famine resulted in almost 5 million deaths. In September 1921, the League Assembly also recognized the urgent necessity of combating the famine. And in March 1922, Nansen reported that the famine had become far greater in extent and far more disastrous in its consequences than anyone had predicted. It was not just that people were dying, but with winter coming to an end, millions were now more likely to migrate from their homes in search of countries where food may be obtained, which would cause serious problems, particularly for states bordering Russia. Closing frontiers, the so-called cordon sanitaire, was not working, surprise, surprise, and the issues had to be tackled at source. In Nansen's view, refugees and famine were but two aspects of a single problem which flowed from the need to reconstruct Russia's economy. This might be a political issue, but international trade and matters of common interest were also involved. At the political level, Nansen had only limited success, but finally an international committee for Russian relief was set up, and in the long term, the League established its health office, which implemented practical alternatives to border closure and dealt with the causes of the epidemics at source, so that migration came to an end. Now, Nansen assumed the post of High Commissioner in early September 1921 and immediately faced the crisis of refugees, absolutely without resources, as he wrote, starving to death in the streets of Constantinople. States readily recognized the need for action, but they were equally concerned that the High Commissioner should not be responsible for direct relief. The refugees may have been a political, social, and humanitarian problem, but the financial aspect tended to dominate. The British government nevertheless made an offer, a conditional contribution of £10,000 of the £30,000, which was estimated would cover the placement of refugees in other countries. This seems to have swayed the council, even if the final results were far less than hoped for. Moreover, even though Czechoslovakia and Bulgaria had offered several thousand places for the refugees, every sort of difficulty was encountered when it came to visas, to transit and transportation. And even refugees who had the means to travel but no passports ran into similar problems. And it was on the issue of passports, or rather certificates of identity, that Nansen had his first major success internationally. He secured the agreement of governments under the arrangement of 5 July 1922 to issue identity certificates to Russian refugees, a simple administrative step which was highly instrumental in their ultimately finding solutions. Almost all League members adopted the system, together with Germany, a non-member, and it was extended to other groups of refugees through the 1920s and 1930s. This was a key development for Nansen, who saw his primary goal as promoting refugee self-reliance, if not where they were, then through resettlement in other countries where work was available or the cost of living was cheaper. Needless to say, he regretted that governments had spent so much on short-term maintenance rather than on facilitating employment or productive enterprises. So we see so many of the problems and so much of the jargon is so dissimilar, so similar to what we hear today. Now, many of the shortcomings of the emerging regime were noticed at the time. Not only did millions of refugees fall outside the safety net, refugees were defined by reference to national origin and being without protection, but it was increasingly difficult for refugees to find employment at a time of economic depression. Borders were tightening up, and the League itself was entering its first period of decline. Totalitarianism was gaining ground, League members were engaging in aggressive war, and the early idealism was slipping away. Moving ahead takes us to the creation of the Office of the UN High Commissioner for Refugees in 1950, and the conclusion on 28th of July 1951, the 1951 Convention. Today, these remain the basic building blocks of the present International Refugee Regime. Turkey signed the convention within days on the 24th of August, but ratified it somewhat later on 30th of March 1962. It was on the latter occasion that it registered, as it was entitled to do, its declaration of a geographical restriction, limiting its convention obligations to refugees whose well-founded fear was due to events in Europe occurring before 1 January 1951. And it maintained this position as it was again entitled to when 6 years later, on the 31st of July 1968, it ratified the 1967 protocol, which otherwise did away with the dateline and rendered the refugee definition universal. No other international instrument has emerged in the past 50 years, despite increasing numbers of refugees traveling farther and farther in search of refuge, despite the protracted and intractable nature of displacement, the lack of formal distribution mechanisms, whether in relation to people or financial responsibility, the institutionalization of protection and rights, and the complexity of causes and drivers. Why then, with all its faults, does the 1951 Convention retain support? Before suggesting an answer of sorts, let's look at some of the challenges. First off, there is the challenge of the temporary. We know that while some few instances of population displacement may turn out to be short-term, we cannot ever count on that. As a consequence, our provision of protection cannot be temporary, but instead must be oriented indefinitely towards durable goals: education, qualification, decent work, security, and integration. Thus, over the medium to long term, we can lay the groundwork for the day of return, a day never to be known in advance and possibly never to arrive in the lifetime of the refugee. If we are proven wrong, if return happens earlier, then we are all winners. Those returning will be that much stronger, that much better qualified, that much more able to rebuild and to start again. More than that, they will be ambassadors for their country of refuge, a worthy return on our investment in their human capital. The reality, sadly, of course, tends to be otherwise, with increasing numbers of states tending to adopt temporary solutions, as if that would somehow deter more arrivals and have no effect on those so penalized. Now, the challenge of protection. The essence of refugee protection today can be stated quite simply. The refugee is someone whose status is defined and recognized by international law, both under treaty and as a matter of customary international law. He or she, the refugee, does have a right to seek asylum, and the search for refuge is not a criminal act from an international law perspective, whatever states may pretend. It follows that refugees in search of protection are not to be penalized because of their illegal entry or presence, and that each claim must be examined on its merits. The state must ensure that its international obligations are implemented effectively and consistently with the rule of law at the point of contact between the agents of the state and individuals claiming protection, for example, during rescue or interception operations and in what follows next. The necessity of protection is itself driven by obligations which are rooted in general international law. The triggers for responsibility and therefore for liability in the case of non-compliance are knowledge of groups at risk, awareness of the applicable law, and capacity for action. Even if individual states are stretched, the capacity of the international community is not. Above all, as many years of sufficiently conforming practice have confirmed, the refugee must not be refooled. There are gaps and grey areas which states can exploit in their own interest, the gap between non-refoulement and asylum, for example, which human rights is seeking to bridge. But the core of obligation is clear, and the fundamental rules of the International Refugee Regime are primary in the sense that unless there are very exceptional circumstances, they can override or trump other important interests commonly expressed in terms of sovereign powers. They change the picture. They lay down the conditions for subsequent state conduct, not to return a refugee, not to penalize a refugee by reason of illegal entry, to deal with the person as a refugee, and in the framework of protection and cooperation solutions provided by international law and its institutions. However, and again, such primary rules do not necessarily provide solutions for every resulting problem, even if they are the essential juridical basis, the framework on which other subsidiary rules may be attached. Thus, measures which ensure that those affected are not left to subsist in conditions incompatible with human dignity and inconsistent with human rights, law will need to be implemented, if necessary, in active cooperation with states generally. This may mean the provision of temporary accommodation at borders or even straddling borders. Presently, however, it's clear that control powers are being asserted and exercised on borders that exceed any permissible scope and undermine the rule of law, which is the foundation of the international community. Next, let me talk to the challenge of solidarity. Apart from being self-evidently a good thing, what is international solidarity? Where do we find it? What are we going to do with it? What does it have to do with protection? In French, from which the English is a relatively recent borrowing, solidarité refers to a relationship between people who, having a community of interests, are linked one to another, and so to the sense of a moral duty towards other members of a group based upon an identity of situation of interest. Whether in English or in French, solidarity seems most apt to figure in the regime of protection. Here, international solidarity is the necessary antidote to that national egoism which might otherwise frustrate observance of the fundamental principle of non-refoulement or the achievement of durable solutions. Not surprisingly, solidarity figures often in the EU treaties. The Treaty on European Union includes solidarity after the values common to the member states, and in the Treaty on the Functioning of the European Union, it occurs in many places. Article 67.1, for example, on the area of freedom, security, and justice, reminds us that the Union, and I quote, shall ensure the absence of internal border controls for persons and shall form a common policy on asylum, immigration, and external border control based on solidarity between member states, which is fair towards third country nationals. Article 80, winding up the chapter on immigration and asylum, recalls that these policies should be governed by the principle of solidarity and fair sharing of responsibility, including its financial implications. So far, so good, you might think. But what does it actually mean in concrete terms? How can it be translated into the international field of refugee protection? And what is refugee protection and how might it and refugees benefit from international solidarity? Within the limits of the EU asylum acquis, the framework established by the 1951 Convention and the 1967 Protocol, together with what is required by the European Convention on Human Rights, protection can there be understood as using the law and the obligations of states. These are intended to ensure that refugees and those in search of protection are not penalized, expelled, or refooled, that every refugee enjoys the full rights to which he or she is entitled as a refugee, that his or her human rights are guaranteed, and above all, that the refugee has an opportunity for a durable solution. This appears at once to stand in contrast to the solidarity of which the European treaties appear to speak, which in turn looks inwards, not outwards. A reality check, a quick look at what is going on in the world today, in the European Union, in the Mediterranean, shows that protection is just not happening. On the one hand, we have the jurisprudence of the Court of Justice ruling out Dublin returns when member states cannot be unaware of systemic deficiencies giving rise to a real risk of inhumane treatment. On the other hand, we have a report published in April this year by a group called Protecting Rights at Borders, which lists 2,162 cases of pushbacks involving France, Italy, Hungary, Romania, Serbia, Croatia, Bosnia-Herzegovina, North Macedonia, Serbia, Greece, and Turkey. Pushbacks are occurring on a much wider scale, of course, and Protecting Rights at Borders has a limited presence. What is significant, however, are the numbers of asylum seekers who do report being denied access to the asylum process, being physically abused and assaulted, and whose property, including mobile phones, is stolen or destroyed. The law says it should be otherwise. The excessive use of force potentially violates the right to dignity and integrity, contrary, among others, to Articles 3, 5, and 8 of the European Convention on Human Rights. In addition, the right to apply for international protection, including at the border, is expressly protected by Article 6 of the EU Procedures Directive, while protection against refoulement is required by Article 3 of the European Convention and under EU law throughout the asylum procedure. But the French courts have ruled that detention at the border with Italy lacks an illegal basis, but still it goes on. From Italy, without any procedure, migrants and asylum seekers are handed over to the Slovenian border police, which then pass them to Croatia, where they are sent to a non-EU country, Bosnia-Herzegovina. In December 2020, the Court of Justice of the EU ruled in case C-80818 by limiting the numbers of those allowed to enter, systematically detaining applicants and subjecting those applying for protection in unlawful conditions. Hungary had failed to fulfill its obligations under the EU directives. Still, daily pushbacks continue. And in Greece, the standard reply to complaints is just a lie. The Greek authorities and officials perform their duties in full compliance with international law, both at sea and at the land border, notwithstanding the overwhelming evidence to the contrary, evidence which is dismissed as the product of smugglers. The EU's new pact on migration and asylum might appear to offer a solution, a fundamental rights monitoring mechanism, As the European Council on Refugees and Exiles, ECRA, and other commentators have pointed out, is intended to apply to a new screening process, whereas the wrongs being done today and yesterday and tomorrow all take place outside process, away from official border posts. And they are done with the connivance of police and evidently with the knowledge of authorities higher up. In practice, it's proven hard to control the activities of Frontex, the European Border and Coast Guard, about which increasing evidence demonstrates involvement in pushbacks and takebacks to Libya and in the Aegean. Nor is it clear that a reformed scrutiny mechanism such as ECRA has proposed will do any better, even if it does cover all border surveillance and migration management operations. What cannot be allowed to continue is this constant criminalization of civil society and of NGOs that provide support for refugees and migrants, or the prosecution and punishment of asylum seekers for alleged involvement in people smuggling. In two recent Greek cases resulting in terms of imprisonment of 52 and 146 years. Nor does the new pact on migration and asylum offer much help. Instead, as the Commission itself notes, the new solidarity mechanism, I quote, will primarily focus on relocation or return sponsorship. In this context, solidarity will be one way intended to keep the refugee away and to return the refugee promptly. The focus of the new pact on externalization and deterrence, its proposal for a screening process, and member states' tolerance and encouragement of pushback will only heighten the risk of refoulement and ill treatment. Now, today, no consideration of the realities could get by without my addressing the challenge of COVID-19. First, COVID-19 has proven to be a useful distraction for governments which want to allow ill treatment and abuse to continue at borders and on the high seas. At the same time, it's been proven to be a useful vehicle for greater control over migrant and refugee populations. For example, on 14th of May, Australia enacted new legislation with no advance notice and no consultation, new legislation authorizing the indefinite detention of certain individuals who could not be removed either on refugee grounds or because there was no country able and willing to accept them. Ostensibly, this was done in the interest and with the aim of strengthening the implementation of the country's non-refoulement obligations. The very same week, the government's budget included huge expenditure on detention facilities. Secondly, while there have been very few formal derogations from human rights treaties, there have been many derogations in fact. This is important because the process of formal derogation implies certain safeguards. The absence of formal derogation means that such safeguards are missing or diluted. Oversight, monitoring, and the judicial review of police measures, among others, are absent. And there are no or fewer remedies for those detained, for example, in conditions that expose them to the risk of infection. Thirdly, controls over movement, both internally and externally, have been ramped up. Even though many states have not imposed a barrier on access to protection procedures, the means for getting there have been curtailed. As we know, technology is already there at the border and beyond, with drones now engaging in aerial maritime surveillance with little oversight. The level of individual decision-making, we could be moving from a rules-based order to one in which the rule is generated directly by an algorithm, not by human beings, and applied in a context where the lived experience of the refugee and migrant are not, as they should be, front and center. Then there's the challenge of contingency. On many occasions, going back to the 1980s, Turkey has referred to the challenge of contingency, reminding the international community that if states generally do not respond to the needs of refugee hosting countries, they may find that these refugee hosting countries, are simply unable to live up to and abide by basic rules, such as non-refoulement. UNHCR has recently addressed the challenges of externalization, noting that, and I quote, the international refugee protection system depends on international cooperation and responsibility sharing, and that externalization simply shifts asylum responsibilities elsewhere and evades international obligation. The United Kingdom and Denmark have also recently floated the idea of offshore processing, which has now actually been incorporated in the Danish law, although it has no agreements to back it up just yet. In a letter to the High Commissioner dated the 7th of June, 3 Danish ministers argue that any agreement on outsourcing, I quote, must contain sufficient safeguards to ensure full compliance with Denmark's obligations under international law. And it must be based on equal partnership and mutual interests. They accept that when a transfer cannot be carried out in accordance with these obligations, Denmark would accept full responsibility to determine claims in Denmark. The jury is out, therefore, but the experience of refugees transferred over many years from Australia to Papua New Guinea and to Nauru, ostensibly for offshore processing, is not encouraging. Irreparable harm was done to the health and well-being of hundreds, owing to indefinite detention, the standard of accommodation, and threats to security, among others. A very real challenge. The ultimate challenge, though, is that of political will. What is not in the convention is significant. When states came to draft the 1951 convention, they expressly declined to write in specific obligations on cooperation, which the then UN Secretary General saw as crucial to an effective regime. His suggestion for an article on burden sharing was rejected, as was his proposal that states give favorable consideration to admitting refugees. Similarly, one of the largest gaps, as we know, in the convention system is the lack of any provision determining which state should be responsible for deciding on claims of protection. And it is precisely in these areas, causes, cooperation, and responsibility, that the International Refugee Regime reveals its incompleteness. And this helps to explain many, if not all, of the actions taken by states, particularly unilateral actions, and the concerns which many also share. Within the International Refugee Regime at large, the bases for discourse and cooperation have been strengthened over the past 70 years, but the politics remain resistant to such fundamental changes as are needed, either to deal effectively with causes or to bring about prompt and equitable solutions consistently with the demands of international justice. And this means not just or only repatriation, I suggest, but also compensation for the injustice that prompted flight in the first place. On the one hand, international refugee law and the convention regime have demonstrated their dynamic character. Within the legal framework, such as the refugee definition, they have shown themselves capable of responding and evolving positively to the emerging protection needs of groups and of individuals at risk, while the normative background provided by human rights has strengthened the capacity of the system to provide a principled approach to larger groups and categories of displaced. On the other hand, as I've said several times already, the law alone does not provide solutions. Certainly, much remains to be done in the face of bureaucratic ineptitude and the bankruptcy of policies premised on the illusion of deterrence and the value of cruel and inhuman practices. There are deeper questions also. Because the regime provides no answers to certain key questions, because these need to be negotiated and renegotiated at each successive crisis, therein lies part of the answer, part of the explanation of why the convention continues to attract support. With so much remaining negotiable, states can maintain the illusion that everything is under their control. The law, however, can still surprise them. Thank you.
Thank you. Thank you, Guy. For us, it was a feast, but it was a feast that kind of leaves one deeply saddened and reminds us that it's not only the Refugee Convention that is challenged here, but it is the rule of law principle that is challenged. Not just in the country in which we're holding this event, but across the world. And what is more sad is that it's occurring in the very countries that many other countries have traditionally looked up to in terms of the principle of the rule of law. And I really enjoyed the way in which you took us on a journey to the very early days of this regime emerging right after the First World War. But then in your presentation, you also made this point how the League of Nations lost its steam as totalitarianism rose in Europe. I know there are very prominent historians, including Margaret Macmillan, I think, that warns us about the similarities between then and today. But I would still like to salvage the day, Guy, because for us, today, I mean in the narrow sense of the word us, IGAM, is also a day of celebration because we are blessed through the process through which we elected or selected two winners of the awards that I made references to. And in that process, just solely in that process, let alone in the broader picture, we saw the number of people who have mobilized themselves to serve refugees, to support refugees individually and sometimes in a more organized manner. And these individuals are not just students or civil society activists, they are also government people, you know, in the depths of the Turkish bureaucracy or in the corridors of local government. So Murat Hocam may reflect on this, even though Turkish public opinion surveys suggest that there is deep resentment against refugees, which of course undermines the political will, the once strong political will of the government to support refugees. In relative terms, refugees in Turkey have enjoyed a decent degree of protection and also acceptance, although that acceptance is eroding. So I felt the need to flag this aspect of it, even though I do acknowledge the severity and the somber picture that you have drawn about where the convention and its principles and the ambience it represents, and that the fact that that erosion is mostly occurring in the very countries that claim to be democratic and cradle of the rule of law. And then, of course, there is the rest of the world, from where many of these people find obliged to run away from. I recognize all that, but in the name of today, I would like to flag out the tiny bit full side of the glass. My question before I turn to my colleagues is this point you rose towards the end of your presentation about burden sharing and how the 1951 convention or the drafters were unable to put into the convention a kind of obligation for countries to share the burden. This is very pertinent to Turkey. And in all fairness, it's not that there is no burden sharing, but the kind of burden sharing that is coming from the European Union falls short. And if there are any government people who may be following us today, do you have any recommendations on how they, meaning government people, could for sure the way in which the president of Turkey has tried to coerce the international community to share this burden has backfired. and it even led to a tragedy to unfold, which weakened his hand in the first place last year, late in February and early in March, when some migrants and refugees made their way to the border with Greece. But what else? I mean, I sometimes can't help but try to understand and appreciate the frustration. But what other ways would you be able to suggest to mobilize greater burden sharing, not just for Turkey, but for other countries that are in similar situations, you know, not to mention Lebanon, Jordan, or for Bangladesh, and today Sudan, that is receiving refugees from the Tigray province of Ethiopia. We tend to forget in Turkey that compared to those countries, I think Turkey enjoys more burden sharing and has more resources to deal for the time being with these refugees. But to cut a long story, do you have any suggestions, recommendations that could be acted upon to whip the international community to be more generous?
I wish I had the answer. I do know, though, from my own experience of Turkey, how Syrian refugees have been received. And my impression from a visit to Gaziantep and Kilis back in 2015, some time ago now, how generous was the response at that time. I was saddened, therefore, to read the reports of the public opinion polls indicating that there's this difference of opinion between the refugee on the one hand and the people of Turkey on the other. I would be interested to look in more detail at how that survey was carried out. But to get to your point, do I have an answer to the question? Yes and no. I mean, I think what we do know is we know what doesn't work. Confrontation doesn't work, as you mentioned in your example from March last year, with migrants and refugees, as it were, heading for the border. That doesn't work. Neither does it work for the EU to insist on readmission on deportation, to insist that it will use visas as a lever to bring pressure to bear on countries which could be ripe for readmitting asylum seekers, nationals, and third country nationals. There has to be a much more cooperative approach. And enabling states to present a cooperative approach is the challenge. There are clearly forces at work, elements in the EU, which are negatively inclined towards refugees and migrants. How can they be sidelined or persuaded to come over to the light side from the dark side? I'm not sure. I know it can be, I think it can be done because it has been done in various individual instances. But that, I think, is the basic proposition, is that coercion and confrontation do not work. Approaching these issues on a basis of equity, I think, has a much greater chance of success. I am also, although I may have ended on a somber note, I'm also particularly encouraged by the extent to which I discover the involvement, the engagement of individuals from all walks of life, whether in government or students or elsewhere, in pro-refugee movements. And I see this here in Australia, where the more people learn about how Australia has treated those sent to Manus and those sent to Papua New Guinea, actually creates a sense of outrage. This is not, the Australians say, this is not how Australians act. This is not how we behave. And the more they learn, and the government has attempted to stop this through carrying everything out, I mean, doing everything off sea, thousands of miles off sea, offshore, away from Australian migrants. And in imposing secrecy requirements of those who work in those areas, it has nonetheless got through, and it will get through. And the government is now, I think, thinking about alternatives to this process, which is inhumane and does terrible damage to people with no known purpose, no clear purpose in mind. So I'm inspired by the extent to which individuals and groups are moved by the plight of refugees, provided they can get the information that's going on. So it's not all somber by any means. And that's what I meant when I say the law has some surprises, because the cutting edge of protection, it seems to me, has generally begun at the grassroots level, when individuals, lawyers, advocates, groups have got together to defend refugees in court and managed to establish the rights of the refugees through the highest courts in the land or through changes in practice. So I'm encouraged the law will surprise us all.
Many thanks, Guy. I couldn't concur with you more, and especially on the point you made about cooperative approaches, which is reflected in the groups and individuals you're referring to. In Turkish, we have a saying that sweet talk can drag a snake out of its den. That, I think, is very telling. And the little story you referred to about Australians is very much a reflection of that. If you engage the law, if you mobilize support, and often you're going to put the officials in an awkward situation where they have to revisit their practices. Now, I'd like to turn the floor to Nihal, who is our host, so that she can manage the questions and answers part of today's event beyond me. I still am feeling a bit uncomfortable because I can't see everybody other than the five of us. And Nihal is much better equipped technically. So Nihal, can you help me please and take on some questions and answer and comments that there might be. Thanks.
Kemal Hocam, of course, with pleasure. And first of all, I would like to also thank, warm thank to the professor. It was a very crucial remarks and valuable statements. Thank you so much. So I have also my own question, but as a moderator, I will be I'll be waiting. So first of all, I would like to give the floor to Metin Çorabatır and then Murat Hoca. Then we have a couple of questions from YouTube. So it will just go like that we try to make a good discussion. Metin Hocam, please. Hocam, you are muted.
Thank you very much, Nihal Hocam and Professor Goodwin-Gill. Many thanks for this inspiring conference. You mentioned that the leadership issue, the political will, and lack of political will, as I understood. And this brings us to lack of leadership, political leadership for the plight of refugees. Chancellor Merkel, for example, in 2015, 2016, played such a leadership role to an extent within the EU group. Now, my question is about the role of UNHCR. Is it diminishing or is it changing? Would it play better leadership role? You mentioned also when answering to Kemal Hoca's question, you are optimistic about the role of individuals, groups, etc. But there's a kind of leader today than before. We need more leadership. And I personally do not see such an active, proactive role of UNHCR. It is more silent and it goes to different directions. How do you evaluate UNHCR's current leadership role in improving, promoting the international protection and international refugee law? Thank you very much.
Yes, I think leadership is critically important. I think Merkel showed wonderful leadership at a particular time, but then it seemed to fade away. I think that is the problem. You have to catch it at the right moment. And I think with HCR, with the High Commissioner, he has, to some extent, a difficult path to hoe, given that a former High Commissioner for Refugees is now Secretary General of the UN. And to some extent, he is not in awe, but I mean, to some extent, I think his policies may be subdued because of his apprehension regarding the Secretary General's knowledge and aspirations in regard to refugees and migration, which is a shame. Because I do think that the UNHCR, the High Commissioner for Refugees, should adopt a much more proactive approach to protection, At the moment, it's all about the Global Compact on Refugees, and protection is in there, but that's to say it tends to be subsumed within the category of broader activities. I think there is room for more active leadership, and I think he needs to elbow his way into the discussions more actively.
Thank you very much.
Thank you so much. Now, Murat Hocam, please.
Okay. Dear Professor, thank you very much for the excellent presentation. It was really very good. And I have two different questions. One is about the differences between a refugee and migrant integration process. I'm working on a lot about the social cohesion, and I try to also understand what's the challenge, what's the concept, how can we make better, etc. And in a European country or Canada or US, etc., if we talk about the integration, the subject is always the migrants. But we have another challenge. And I want to also ask that, can you see also the, can you explain us the differences between refugee integration and migrant integration? It is my first question. And second is about the Turkish-EU relation for refugees. How sustainable is such kind of relations? How can we make better? Can you give us some idea for that? Thank you very much.
Well, there you catch me on an area where I don't have a great deal of practical knowledge. I can maybe suppose that there are differences between the refugee and the migrant at the point of integration. And I can say that they are relatively formal in the sense that the migrant has, as we know, somewhere to go home to and the refugee doesn't. But basically, I see them coming together because, as I said, the measures taken on behalf of the refugee cannot be premised upon the notion of temporariness. One cannot assume that the refugee is going to go back in due course. One can hope that the refugee may be able to return to their country of origin, but one cannot count on it. One therefore has to plan with indefiniteness as the goal. And that means planning long-term in terms of education, qualification, and skills gaining. One cannot assume that there is an immediate day of return just around the corner. So to some extent, the migrant and the refugee come together there, because likewise with the migrant who needs to integrate too, one should also think long-term, not short-term. Short-term benefits, short-term goals do not tend to bring benefit to the migrant, as we see, for example, in the history of migrant labor in the Gulf states. There it is entirely short-term, and the benefits are not very great indeed. Now, on the second part of your question, I'm afraid, what was it? Could you repeat it, please?
It was about the Turkish-EU relationship and the Turkish-EU refugee deal. How sustainable is that? It was my question.
How sustainable is it? Well, yes, that goes a bit to the temporariness as well. I mean, how many $1 billion has the EU contributed? And it's $6 billion, is it not? And how much more can it contribute? It seems to me that the EU can go on forever, because it does have the resources to contribute to refugees in Turkey. And it should do, because without that contribution, refugees are going to take to the road and head for Europe once again. So I think in principle, there's no limit to the extent to which the EU can contribute to the refugee situation in Turkey. It may be able to reduce the amount of funds, as if we assume, for example, that refugees do end up remaining long-term, they may become self-sufficient, and it may be possible for the EU to reduce its contributions. But there are schools to be maintained, there are jobs to be encouraged, and so forth. And I see no end to that possibility, to that commitment that should govern the EU's approach. Thank you.
Thank you very much.
Thank you for all these questions. And if you don't mind, I would like to ask my question and then return back to you two questions. And dear Professor, what is your opinion of Turkey as a safe third country from a legal point of view, and which is quite linked to this question as well? What do you think about the construction of a safe zone in Syria for refugees? Do you think that it's realistic and feasible for the voluntary return of Syrians in Turkey?
So what do I think about Turkey as a safe third country? Well, Greece apparently has determined that it is a safe third country, has it not? But is it? One has to wonder what was motivating the Greek approach to this and whether it has taken into account all the facts relevant to the particular refugee groups in question. I don't know whether Turkey is a safe third country for those groups in question. I would suspect it may not be. And therefore, an individual approach has to be taken to determine safety in each case. With respect to the construction of a zone, well, it might be feasible. I mean, zones, the no-fly zone in northern Iraq in the 1990s worked. It prevented the necessity for Kurds to leave, for example. Perhaps something similar could be worked out in Syria, but it would need a very great commitment. It would need, amongst other things, boots on the ground, as the American military would say, because you have to protect the safety zone in order to ensure that people can go back and can maintain some sort of a living and livelihood there. It would have to cover quite a vast area of land if people are to go back there, because people are going to need jobs to do. They're going to need schools. They're going to need services. So it's going to be quite a reconstruction phase, it seems to be, given the destruction that's been visited in Syria over the past years. So in theory, yes, possible. In practice, I wonder, given the commitment of resources, military and others, that are going to be necessary. Thank you.
Thank you so much. And our question from YouTube, yeah, they are asking about something for World Trade Organization. World Trade Organization has enabled clause which provides a possibility of trade concessions, flexibility in the application of WTO rules to the least developed and developing countries. And starting from that point, do you see a possibility of a similar mechanism of trade concessions to countries like Turkey, who host largest number of refugees in the world?
Yes, well, that again is one of the high points of, one of the developments that has taken place over the past 10 years. It's to bring in the wider range of UN agencies in support of action on behalf of refugees. And that is to be welcomed. Certainly measures like this, like special measures for LDCs and Turkey and other, well, Turkey's not an LDC, is it? But special measures which would allow for the investment and better involvement on behalf of refugees are greatly to be welcomed. And the World Bank also is involved, and I think should be encouraged to widen its reach in that regard. So greater involvement by the World Trade Organization with trade, and greater involvement with the World Bank on cash.
Thank you so much for being with us. It was a great honor for us. And we hope that after pandemic, we could have a chance to invite you directly to the Turkey and host you in Ankara and in Istanbul or anywhere in Turkey. So now I would like to give the floor to Kemal Hocam for the closing remarks, and then we will close the session. Please.
Thank you. Thanks, Nihal. Thanks, Guy. On the very last point there, engaging the wider UN family, I think it's already happening, and we observe it through especially the 3RP system and the way in which there's an effort through some of the ideas in the Global Compact on refugees to support self-reliance and resilience of host communities. But this trade issue I find very fascinating, and it is in the compact, but the challenge there is how to put it into effect, how to mobilize it. And in many ways, in your remarks to Murat's question about how to move forward the EU-Turkey partnership on this issue, you did mention how the EU, to put it in street language, should continue to cough up the resources. You mentioned education costs, but also jobs cost. We, Nihal and Murat Hocam, we've been working on this a little bit. We think that one way of creating jobs is also through trade concessions. But the dilemma is there. The dilemma is, where do you get the ball rolling? You know, from where should one start? It looks like Turkey and Qatar, in the previous ministerial meeting of the World Trade Organization, brought up the idea, but it wasn't, it fell on deaf ears. it may have had a lot to do with the fact that at the time, Turkey had an awkward foreign policy where it thought that bullying people can deliver results rather than adopting a sweet talk approach. But what ideas would you have with respect to where one could start? And you made references to the World Refugee Council's report. There too, they bring this up, but the key is how to get that ball rolling on it.
Well, you certainly ask me easy questions, don't you? I don't know what the answer is, quite frankly. I mean, I think that there are many obstacles in the way of implementation. I can see one of them that would be raised by citizens, for example, seeing themselves potentially prejudiced by the operation of measures to support refugee industry, if you like. So I think somehow one has got to make sure that the application of funding and resources is non-discriminatory in that sense. You have to benefit the host community as much as the refugee community. Make sure that they can see that each is benefiting from the presence of the refugee in their midst. I think that's one guiding principle. How do you get it started? I think you have to start small. I think you cannot start with a massive WTO EU project. I mean, the projects have been tried in Jordan and Lebanon, certainly. But I think small is the way to begin, with contributions, for example, from Canada or in one area in particular. Get things off the ground. I think that is the way to go.
Thank you, Guy. We better let you off the hook and give you some time to recover from the World Refugee Day. I thank you once more. I thank the audience for their interest, and I also thank my friends and colleagues here, especially Nihal. So we wish you a good rest.
Thank you very much.
And hope to see you soon in real, somewhere around the world, preferably in Istanbul.
Yeah. Okay.
Thank you very much.
Say hi to Sharon as well.
Yes, I will. Okay. Bye.
Thank you very much. Bye-bye.
Thanks a lot to our followers as well. We are coming to the end of the program and end of the day. So please follow us on our social media. And once again, hope to see you soon all in another YouTube program. Bye-bye.